Our next presenter this afternoon will be Ms. Mechelle Martinborough, who is joining us from the Securities Commission of the Bahamas. Ms. Mechelle Martinborough is a Deputy Executive Director, Senior Legal Counsel, and Secretary to the Securities Commission of the Bahamas. Prior to joining the Commission, she was a prosecutor in the Office of the Attorney General. She was also a civil litigation attorney at McKinney, Bancroft and Hughes. Mechelle recently oversaw the overhaul and amendments to a compendium of legislation, including the Securities Industry Act, the Digital Assets and Registered Exchanges Act, and the Investment Funds Act. She serves on the committee at a national level to overhaul and amend the existing company's legislative framework. Mechelle is also a descendant of the best island in the Bahamas, and that would be Long Island. Please join me in welcoming Mechelle Martinborough.
Good afternoon, everybody. It seems like you guys have been having a great day, and I hope that I'm not here to put any sort of a damper on it. But thank you very much, Raquel, for that really warm welcome. I appreciate it, and I'm happy to be here with you guys today to talk about the Bahamas' Digital Assets Framework, the DARE Act, how it came about, and to give you a summary of the recent amendments in the Act. So the way I hope to get through that is by walking you through the development of the DARE Act 2020, providing the background and scope, to do a review of the amendments that got us to the DARE Act 2024, and to talk a little bit, give you a quick summary of what's new in the DARE 2024, a more detailed summary. I don't know how you have a detailed summary, but you all know what I mean, right? A detailed summary of the amendments, and to just do a quick pick through some of the other aspects of the DARE Act 2024. So, let's get started. As the statutory regulator of the capital markets in the Bahamas, the Commission monitored the digital asset space for several years. We observed the potential that the space represented for our wealth management industry to grow, but more importantly, the threat represented if the space was left behind or was allowed to grow and develop absent appropriate regulatory, consumer, and investor safeguards. We also fielded intense interest from international and domestic digital assets businesses, and consistent with our threefold mandate of protecting investors, facilitating clear and efficient markets, and reducing systemic risk, saw the need to provide legal clarity for operators in this space. Importantly, in consideration of the distinctive businesses, assets, technology, characteristics, and risks associated with the still developing digital assets sector, a key determination of the Commission's research to create a bespoke legal and regulatory environment for digital assets, rather than to rely on the uncertainty within existing legal and regulatory frameworks, which neither clearly scope digital assets nor holistically define the characteristics of digital assets businesses that ought to be captured in a regulatory framework. Put more succinctly, what that really means is that when we looked at the area and what was happening in the industry, we didn't see where a proper regulatory framework could fit in the laws that we already had. So they didn't fit into the securities industry framework, they didn't fit into investment funds framework or financial corporate service providers. So we decided to create our own digital asset framework for regulation. During this development period, the Commission also determined two important principles. Firstly, that the legislation would take an activities-based approach to regulation to regulate the stated or intended activity rather than the technology. Secondly, we aim to develop a risk-based supervisory approach. In this regard, DARE does not predetermine any particular digital asset business activity as high risk, but rather the risks are determined through a robust and transparent assessment of the nature, scope, and complexity of the respective digital asset activities. Benchmarking was crucial to the Commission developing a world-class legal and regulatory framework for digital assets. Much of the, sorry, let me just check to make sure. I'm really bad at coordinating the clicker thing and the slides. So if I get lost, if you could, that would really help. What I'll try to do is give you some kind of secret signal. Okay, thank you. I'm so sorry about that, guys. But benchmarking was crucial to the Commission in developing a world-class legal and regulatory framework for digital assets. Much of the initial benchmarking work was performed internally by our Policy and Research Unit. Then a leading international consultant was engaged to support us in the research phase. The consultant performed additional benchmarking, and in all, 13 jurisdictions were benchmarked carefully, considering the various regulatory approaches of each jurisdiction. And just to give you an idea of the breadth, we went from US to Japan to Malta to Barbados, Bermuda. We did quite an extensive benchmarking. We found that people took a myriad of approaches. In Malta, they actually had a framework that based their regulation on the technology, which ended up not to be the right approach. And so give us a hand, we did pretty good in deciding not to go that route. And then we also had a lot of jurisdictions that were taking the sandbox approach, like Bermuda, I think Australia and New Zealand, if I'm not mistaken. I think they both undertook, the three of them took a sandbox approach. We decided we weren't particularly comfortable with that for a number of reasons, including the fact that we didn't see the business being domestic business, and it was difficult to see how we could regulate something that was basically being business that was basically being conducted internationally from here when we didn't have a regulatory scope. Crucial to the development of DARE was ensuring that the Bahamas continued to meet its international commitments to the global fight against money laundering, terrorism, and proliferation financing. As such, robust and globally compliant AML, CFT, CPF provisions were included in DARE. These provisions were informed by the guidance issued by international standard-setting bodies, such as the Financial Action Task Force. And DARE was then subsequently augmented with the Digital Assets and Registered Exchanges AML CFT CPF rules in March 2022. With its adoption, we should be on slide. Oh, we are? You're good. Okay, sound gotcha. With its adoption, DARE accomplishes some critical things. Notably, DARE creates a legal definition for digital assets, which are broadly defined as digital representations of value, which may be transferred and stored electronically using distributed ledger or similar technology. DARE defines what constitutes digital asset business, and as a result, would trigger registration with the Commission. This includes both digital token exchanges and the issuance or sale of digital assets. DARE obliges digital asset businesses to have the same full set of anti-money laundering, counter-financing terrorism, and counter-proliferation, all those letters, CFT, CPF, every other letter they could find to throw in. AML was the other one. All of these obligations as traditional financial institutions such as banks. DARE, however, does not apply to individuals acting in their professional capacity who are working on behalf of persons engaged in procuring the organization, promotion, issuance, sale, or trade of digital assets. These include lawyers and accountants. Digital assets that are used within a game, sold by a publisher, or offered on a gaming platform are also not included. Non-fungible tokens, insofar as they are not used for payment or investment purposes, are unable to be sold in a secondary market, are also not captured. And finally, DARE does not apply to central bank digital currencies, which for the purpose of DARE are not defined as digital assets, but instead are electronic representations of fiat currency. In summary, DARE established a robust regulatory framework that was designed to protect investors and consumers, align with international standards, yet remain sufficiently flexible to adapt to the ever-changing digital asset landscape. Since its adoption, DARE has been recognized internationally for its investor protection features and its globally compliant AML-CFTPF framework, including being assessed as fully compliant with respect to the effectiveness and implementation of the FATF's Recommendation 15. Just for your general information, we currently at the Commission have 22 entities licensed under this legislation. Since the enactment, the Commission has continually sought industry feedback, conducted internal reviews, and submitted to international assessments of DARE. Additionally, we kept abreast of international regulatory digital assets advancements and continuously benchmarked DARE with comparable frameworks from jurisdictions such as the European Union, Hong Kong, the US, and in particular in the US, New York. Significant developments in the digital asset space have continued since the DARE Act 2020 was enacted. By the time as the crypto winter fell in 2022, the Commission had already begun to see new risks that were not apparent in previous years or even relevant to prior months. Consequently, the Commission identified aspects of DARE that required further consideration. In April 2022, we began consolidating our ongoing review of DARE for the purposes of addressing any legislative gaps, ambiguities, and procedural concerns within the legislation to help address these revisions. The Commission engaged the international law firm of Hogan Lovells to draft the amendments of DARE and benchmark the DARE Act 2024. So, what's new in the DARE 2024? Of course, we had to add in some additional definitions and interpretations because we added new stuff. We then also expanded the types of digital assets that would fall within the scope of the legislation and would include certain services such as providing advice or management of digital assets. We have also covering new services such as providing custody services, staking services, as well as the issuance of stablecoins. There are also foundational provisions for financial and reporting obligations. There are additional requirements related to digital asset exchanges, and we've enhanced the framework for digital asset issuers. The conduct requirements in the Act have been expanded to include conflicts of interest, as well as to specify certain market abuse offenses, and we've enhanced the AML-CFT provisions so that we now specifically require a compliance officer and an MLRO, as well as set out what their obligations are in relation to the sector. The DARE Act will capture a wider range of digital assets activities relative to international standards and is much more comprehensive in registration scope in comparison to the DARE 2020. So the DARE 2024 is a lot more expansive. New digital asset business activities that require registration under the DARE Act include advising on digital assets, managing digital assets, providing digital asset derivative and DLT network node services, and providing staking services. As the sector is constantly evolving, this list is not exhaustive, and the Act provides the ability for the Commission to prescribe additional activities as digital asset businesses are necessary. Operators of digital asset exchanges must align their systems and controls with the scale and nature of their businesses. Exchanges must segregate customer assets from their own, providing enhanced protection for clients. The Commission has the authority to prescribe additional rules for digital asset exchanges as necessary. If an entity establishes and operates a digital asset exchange that also provides custody of digital assets, it must comply with all relevant regulations applicable to the digital asset business. This includes exchanges that provide custody services as an ancillary service to the exchange. So the one other element to this exchange, to the framework within the exchange, is that it is an additional element. It is not just that they only have to comply with those specific provisions. They also have to comply with all of the other regulatory framework that applies to the whole category of digital asset businesses. So it's they have a double level of obligation. The DARE Act 2024 introduces a single comprehensive framework for custody of digital assets, repealing the applicable provisions under the Financial Corporate Service Providers Act, prioritizing the protection of client interests. Regarding custody, the DARE Act contains several requirements specifically concerning the segregation of client assets from the assets belonging to digital asset business or other non-client assets, including the requirement to maintain separate accounts to ensure client assets are insulated from creditors. What I would want to note here is that while we have a regulatory framework for custodians, we've not required custodians to be registered with the Commission. So once you're in the business, you can conduct the business, but you have these standards that you have to comply with. In instances pertaining to insolvency and where client assets are held under an omnibus arrangement, the custodian must maintain appropriate procedures in order to be able to identify at all times the digital assets and transactions belonging to each individual client. The DARE Act also sets out a robust framework specific to digital asset businesses, providing custody services such as in relation to their ability to return client assets and to maintain procedures to ensure the continued safekeeping and accessibility of digital assets in event of unexpected disruptions. The DARE Act 2024 introduces a first-of-its-kind dedicated disclosure regime for staking activities that promotes transparency and accountability within the digital asset ecosystem. It captures the activity of the staking of digital assets belonging to clients or the operation or management of a staking pool as a business. In practicality, participants in a staking pool pledged their own digital assets to support the work of a network and are usually then rewarded for pledging their assets. The Act is a leading piece of legislation relative to international standards for its explicit inclusion of staking services within its scope. Under the new Act, registrants must disclose certain information to clients, including a summary of the terms of the client agreement, details regarding the staking protocol, details of how the digital assets are staked, such as how long assets are locked up for, details of rewards or interest to be earned, details of any penalties which may be imposed, and the procedure by which staking participants are chosen to validate transactions, and any other information as may be required by the Commission from time to time. The intent is to capture the activity of staking as a business, not to capture individual staking for their own account. So those individuals will not fall within the remit of the Commission. Individuals or entities that issue digital assets in or from within the Bahamas must comply with additional obligations aimed at protecting investors, primarily as it relates to initial token offerings and registration of existing tokens. These include fit and proper requirements for the issuer, the requirement to prepare an offering memorandum, the contents of the offering memorandum, registration of initial token offerings containing certain information, and continuing disclosure obligations. There is a new voluntary registration regime for persons who issue digital assets from outside of the Bahamas to persons outside of the Bahamas, or otherwise not in scope of the issuer requirements under the new DARE Act 2024. So what we think we've created here is an opportunity to grab business that doesn't necessarily take place in this jurisdiction. What this is a framework that allows market participants here to actually partake in issues that may take place outside of the country, but because they want to be regulated and they like the framework that we've established, we will review them, consider whether or not we think it's a worthy risk, and we might approve that a market participant here, or that registration, that issue could be registered within the Bahamas. A new component introduced in the DARE Act is that the obligation to file an offering memo in the Commission does not apply in prescribed circumstances, such as if the DARE assets are distributed as a reward for the maintenance of a DLT or the validation of transactions, or if the digital assets are offered to qualified purchasers only, the latter of which is consistent with the distribution and prospectus filing requirements of the Commission's primary legislation, the Securities Industry Act 2024. Also of note, the Act prohibits the issuance of private tokens under the legislative framework. Although digital asset businesses are not prohibited from engaging with privacy tokens or similar tokens that enable or allow reduced transparency and increased obfuscation of the source and or destination in respect of a digital asset transactions are not accepted for registration under the proposed Act. So that is how we try and ensure that our framework maintains the standard required internationally for transparency. So we're not going to allow people to come and issue tokens here that you cannot trace where they came from or where they went to, right? Stablecoins. The DARE Act proposes a new and comprehensive regulatory framework for stablecoins, including defining them as essentially any digital asset that purports to have its value fixed to one or more referenced assets, which assets may consist of any combination of fiat currencies, legal tender, commodities, digital assets, or any other form of reserve asset not prohibited by the Commission. Stablecoin issuers must back stablecoins with reserve assets at all times, and stablecoin issuers must disclose these assets for evaluation by the Commission under the Act. Under the Act, the issuance of algorithmic stablecoins that aim to maintain a stable value via protocols that provide for the increase or decrease of the supply of such stablecoins in respect to changes in demand are expressly prohibited in the Bahamas. Moreover, reserve assets must be available for examination and verification of the issuer's disclosures upon request by the Commission. Further, the reserve assets must be custodied and managed by entities authorized to do so by the Commission. Stablecoin issuers must also publish any event likely to impact the value of the stablecoin or on the reserve assets. The redemption of stablecoins must be subject to reasonable, non-burdensome conditions. And finally, some other aspects that we think are interesting in the legislation. The Act brings a significant set of guardrails to DARE that provide more clarity and legal definitions to its bespoke regime. For example, the categorization of non-fungible tokens under the DARE Act 2024 now depends on the distinction between financial or consumer assets, resulting in financial NFTs falling within the scope of regulation, whereas consumer NFTs do not. Moreover, the Commission has taken proactive measures to address liquidity events through mandatory reporting obligations and minimum regulatory capital requirements, which will have regard to the specific risks applicable to the registrant, while also granting flexibility to introduce additional safeguards for investor protection. Furthermore, the Act introduces specific conduct standards to address market abuses, conflicts of interest, and to regulate connected third-party relationships. The Act also provides certain restrictions on proof-of-work mining of digital assets in or from within the Bahamas. The DARE Act establishes new regulatory frameworks which will keep the digital asset regime of the Bahamas current, proactive, and compliant with international standards and best practices. The DARE Act represents an even greater focus of consumer and investor protection by strengthening the existing protection mechanisms afforded to digital asset participants. Such protections include increased disclosure and reporting requirements for digital asset businesses, expanded activities-based registration obligations for potential registrants, and enhanced ongoing supervision for operators in this space. The Act allows room for digital asset businesses to innovate as the space continues to evolve, an important objective of the legislation, and provides the flexibility for the Commission to prescribe additional rules applicable to digital asset exchanges and bespoke requirements for other categories of registrants. And with that, I'd like to say thank you very much for your attention, and I will take any questions that you may have. It would be interesting for me to see. Thank you. You know, I thought it would be interesting just to ask generally how many of you here dabble or have any experience with digital assets? Nobody? Not you, Sam. Sam is from the commission, so he don't count. Oh, I see one hand in the back. I think I recognize that face. Do I? Yes, okay. So was all of this like Japanese or Chinese to you today? Yeah? All right. I was hoping that it would maybe give you some insight as to what's developing, but I mean, I guess we have to maybe work at breaking it down a little bit more so that it's more on a 1, 2, 3 level, eh? Would that help? But I hope at least it was able to give you some appreciation for the fact that the jurisdiction continues to work in this area. We are keeping abreast of what's going on, and we actually are considered out front in the international community with the steps that we have taken to develop our regulatory regime. Yes, ma'am. Okay, so it actually is a result of the benchmarking that we do. And it's also, you know, a lot of the benchmarking that we don't do ourselves. We actually hire international consultants who will look around the world. We also do a lot of monitoring of what's going on in international press, particularly in this space, because it had become, for obvious reasons, a very sensitive area for us to monitor. You know, so it's very important for us to keep track of where we are as against where other jurisdictions are. So for instance, it's benchmarked. Nobody else has a framework, a disclosure framework for staking, right? When we issued the DARE in the first instance, you didn't have a comprehensive framework in the way that we did. Although, I must say, when we issued the DARE in the first instance, we issued it in a little bit restrained, right? So that what we did was we said, okay, we're going to frame this legislation in a way that we deal with what we have to, but we want to sit back and look at what happens in the market, because we didn't want to restrict the growth of the market by over-regulating it, because we didn't quite understand it. At the time, it was new and moving so fast. You really couldn't figure out exactly what was necessary. And so we stepped back and we continued to monitor, and as we saw new things happen, new risks were identified, we decided that, you know, we needed to update the legislation. And we anticipate that this legislation will be a changing legislation for a while, because the industry is just too new and still growing.
I just wanted to commend you, Mechelle, and of course the Securities Commission, because as we know, financial services is an ever-evolving field, and I think that the Commission has done extraordinary work to move the needle forward in terms of the digital asset space. We've also had the overhaul of the Securities Industry Act this year, and I know that investment funds amendments are underway. Yeah. I would say some of the key takeaways from the DARE amendments that I've seen have been the robust risk management, the resolution framework, which is very similar to if you have, for example, a bank or a trust company that finds itself in trouble. There are certain consumer protections that have been put in place. So there's definitely increased focus on compliance with international standards and consumer protection. And so just want to commend the Commission for its work in that regard and continuing to move the industry forward.
Yeah. Thank you, Raquel. One of our key objectives in the 2024 Act, as you rightly identify, was to ensure that we increase the consumer protections that were built in there. And so things like the disclosure regime in the staking arena, et cetera, will hopefully lend to that enhanced protection.
Do we have any other questions? Before
One question. Thank you very much for a good presentation.
I can't see who it is from where.
Yeah. I mean, I'm one of those persons who don't follow the industry in terms of the DARE Act very closely, but obviously the shock from FTX that we had a few years ago is kind of like the elephant in the room for me. So, I mean, as much as you can share with us, I mean, can you give us an update in terms of how the industry essentially has responded after that? I mean, it's been a sort of a black eye even for us in other parts of the financial services industry. So, I mean, that's an elephant in the room for me. If you
It's always an
that.
elephant in the room, as I think, particularly for the commission as well. You know, we really have been circumspect in how we have dealt with our statements in relation to FTX. But I can say this much. I think that we are at a point, particularly in the liquidation, where we can say that the Bahamas has fared pretty well. We have a liquidation of billions of dollars where most, if not all, of the investors will recoup 100% of their investment, if not more. And that is largely due to the immediate action that the Commission took in securing the assets and preserving them until the time that the liquidators were able to be appointed. And of course, we cannot downplay the role that the U.S. debtors played because they too secured the assets in the U.S. And you know, because of that, we are able to say we've had a pretty successful outcome in a very testy matter. You know, but I think for us, I think that at the end of the day, we've come out pretty well. We're still working. I'll say that much. The matter isn't completely closed for us. We are still working. But that outcome, I think, is great news to spread, right? So, any other questions? Okay.
Okay. Well, thank you very much again.
Thank
Please
you all
give
for
Ms.
having
Mechelle
me.
Martinborough another round of applause.